Te escucho muy bien, Jane. Sí.
Okay, shall we make a start? Okay, welcome to this webinar. It's entitled Environmental Rights and the Legal Community. Very welcome, big welcome to everyone who's joined today. And my name is Richard Dighton. I'm a partner at Simmons & Simmons, but I'm the pro bono partner there. And I'm also chair of environmental charity. I was a chair of the Environmental Charity Legal Response Initiative, and I'm chair of Lawyers Against Poverty. So very interested in this particular webinar today that we're holding. We have a star panel for you who will speak for around 10 minutes each, and I will in a moment introduce them to you. Just before I do that, I wanted to say that this is an interactive debate or discussion, and you will have the facility to ask questions on the Q&A tab at the bottom of the screen, and then we will take those questions after the presentations by the speakers, and we will ask those questions and we'll have a discussion following the presentations. So that's one thing I needed to say to you. The other thing is we have a translation button as well on the screen. If you go to the right-hand side of the bottom of the screen, you'll see there's a translation button, and you can pick a particular language that you want to hear the presentation in. It doesn't matter in terms of the questions or things that we say, but in terms of what you want to hear, you can pick that translation button, and that will help you through that. So I just want to introduce our speakers now, and we're going to have the following people speaking in this order. So Victoria Channing, who's a colleague of mine at Simmons & Simmons, but she is the pro bono manager. So she runs all of our programs on pro bono, and she's also been the author of the toolkit, the Human Rights Defenders Toolkit, that she will speak about. Next, we have Kate Cook, who is an extremely influential barrister from Matrix Chambers, and she has written a report for the UN Human Business Rights Committee, and she will talk about that and how that affects agricultural investment. Next, we have two human rights defenders, Donald Hernandez, who's a human rights lawyer at the Honduran Center for Community Promotion and Development, and he's the winner of the Sir Henry Brooke Awards 2019 last year. We're very delighted to have Donald speaking to us from Honduras. And then last but by no means least, we have Sekar Banjaranali, who's from Indonesia. She works for an NGO, and she's an environmental law specialist, and she's also a researcher at the Institution of Policy Research and Advocacy. And so she's going to give her insights to us as well. So, this is a discussion, environmental and human rights. There's a particular focus, obviously, upon human rights defenders, and this has been organised by Peace Brigades International because of that particular focus that they have. And so there's an issue there that we need to explore. And really, the purpose of this is to sort of inform people about the issues, and also to reach out and suggest ways in which people hearing this can respond and help sort some of these issues out going forward. So that was all I wanted to do as part of the chair's introduction, and I will be facilitating the questions, so please do think of things to ask as the presentations go through. I'm going to now hand over to Victoria as our first speaker, and she's going to talk about the toolkit that I mentioned, but also her perspective on these issues. So over to you, Victoria.
Thank you, Richard, and thank you everybody for joining us today. As Richard says, I'm the pro bono manager at Simmons, which means that I do have oversight of all of the pro bono programs that we operate. And Simmons is very active in the area of environmental rights and the crossover of environmental rights with human rights. And so we do a lot of things in this area, including advising not-for-profits and communities on how to exercise those legal rights. We have lots of experience of advising in respect of grievance mechanisms and remediation when those rights have been breached. And we also, on our fee earning side, give quite a lot of advice to corporates on risk mapping and mitigation, and the importance of environmental and human rights due diligence when commencing a project or when making investments in an attempt to stop any adverse human rights and environmental impacts before they actually happen. We also have experience of revising on both sides of the fence on parent company liability. So where we're advising on legal actions where the entity committing the harm is based outside of the jurisdiction where the harm is actually being perpetrated. So that's a good overview of the sort of things that we as lawyers at Simmons are involved with in this area. But as Richard says, there's one large project today that I want to talk about, and that's our involvement in drafting Human Rights Defenders Toolbox with Peace Brigades International. So I say it's Human Rights Toolbox, but it also has equal application to those looking to defend environmental rights or land rights. So the aim of that toolbox is really to assist those defenders in identifying which international human rights instruments apply to their cases and what steps they can take themselves to further their causes and to resolve these disputes. And it's also a means of engaging a range of stakeholders to encourage companies to adopt more responsible business practices and to ultimately reduce business-led human rights abuses. By way of background, this was initiated by Peace Brigades International and also a collective of Colombian human rights lawyers who had been observing an upward trend in violence against defenders caused by conflicting business interests, particularly in the environmental sphere, caused by extractives and agribusiness companies. And there was an urgent need for these defenders to really build their capacity and understand what instruments were out there that they could use in order to further their cause. So we set about drafting a range of fact sheets in these areas, and produced and launched them in English and then in Spanish as well, given that a lot of these issues do tend to arise in Latin America. And we were very conscious when we engaged with this project with PBI that we really needed to understand the perspective of the defenders themselves. So it's all very well sitting in an office in the UK and reading online about the abuses that are happening in countries around the world. But it's quite another thing to actually speak to those who are defending these rights on a daily basis and putting their own lives at risk. So with that in mind, I, along with PBI and other representatives from other NGOs, visited Colombia and launched the toolbox in Bogota, where we arranged a consultation with local human rights defenders, environmental defenders, and also victims of abuses over there, and then amended our approach and drafts accordingly, just to make sure that it was really relevant to those who were going to be using those that resource. In terms of the focus points, it's primarily focused on the UN Guiding Principles of Business and Human Rights that some of you may be familiar with, but I will leave Kate Cook to talk about those a little bit in a little bit more detail later. But it also covers other international legal instruments and other themes relevant to environmental rights defenders, including free, prior and informed consent, mass tort claims and parent company liability, and operating in conflict affected areas, or where organisations have engaged security companies to protect their interests in these areas. So that was published in 2018. We're currently in the process of updating that fact sheet to make sure it reflects current international instruments. And we also produced a fictitious case study just demonstrating how those instruments could be and how those fact sheets could be actually used by human rights defenders on the ground. And we're very fortunate to have Donald Hernandez here today, who has actually used that toolbox in his work in Honduras. So once, I say that we're in the process of redrafting and reviewing these fact sheets, but we are also in the process of delivering seminars to human rights defenders in different jurisdictions to ensure that they themselves are comfortable with that resource, and they themselves can then disseminate it and use it within their teams and communities on the ground. So that's a canter through what we at Simmons are doing, and I'd be very interested to hear more from Kate, Sekar and Donald about their experiences, not only looking into this from an academic or a practical perspective, but also actually being on the ground, dealing with victims of these abuses.
Thanks very much, Victoria. As I said before, if you do have questions, put them on the Q&A function, and we will take those at the end of the 4 speakers slots. I'm now going to hand over to Kate Cook, who's going to talk to us about UN Business and Human Rights Committee, and also the report that she's written, and what the responsibilities are for law firms and lawyers in particular. So I'm going to hand over to you now, Kate.
Thank you very much, Richard, and thank you for the invitation to speak with such a wonderful panel. I am going to see if I can share slides, so fingers crossed. Yes, is that good? Everybody can see those.
Very good. Yes, thank you.
Okay, so I'm going to talk about lawyers and law firms and the responsibility that they have to respect human rights because they are businesses. And non-lawyers and the wider community might think in relation to the broader issues, why should we be particularly interested in lawyers? I think lawyers are really important. in a positive sense, as Victoria has just indicated, because a lot of lawyers are doing important work, such as the toolkit that she has described in promoting the responsibilities of lawyers and engaging with communities to ensure that human rights are respected, but also because all the transactions that we are concerned with when we're concerned with environmental human rights and defenders, transactions related to land and to investment and rights over land, it must be the vast majority, if not all of those, where at some stage a lawyer has been involved. A law firm has been instructed to advise the business client, the investor, at every stage on human rights due diligence, on drafting contracts, and perhaps assisting with grievance procedures and dispute settlements. So lawyers are at the heart of this. I think sometimes the focus has not particularly been on lawyers, but I think it should be, and I will explain why. So I was asked to author a guide which has now been published by the UN Food and Agriculture Organization. You can see it there. It was published in 2019 and it's freely available on the web. So that guide looks at lawyers' responsibilities under the UN guiding principles on business and human rights. So that's the core of the framework that it looks at. And it focuses on agricultural investment and particularly on due diligence. So it's looking at the way in which, for example, tenure rights are affected by investment and how this translates into human rights issues. So I think the important starting point is that to remember that law firms are businesses in their own right. So they are also have responsibilities under the UN guiding principles on business and human rights, alongside their business clients, investors, and others who are investing in land or rights over land. That means that law firms must ensure that they meet their own responsibilities under the UN guiding principles, as well as advising the clients. And the core responsibility is obviously to respect human rights. And I'm going to talk a little bit about what that means in operational terms. This is a fast developing area. There are many international fora who are looking at these issues, both as business and human rights issues, and specifically in relation to land and investment. And as you can see there, the Committee on Economic, Social and Cultural Rights is currently consulting on a new general comment on land and the Covenant on Economic and Social Rights, and is specifically addressing the question of the emerging human rights responsibilities of business enterprises, including investors. And of course, that also includes lawyers. So the guide, as I said, is freely available, and I'm just going to touch on a few key themes with a specific focus this evening on defenders. The guide, as I said, deals with the UN guiding principles on business and human rights, and it also refers to soft law instruments that are relevant to land tenure and agricultural investment. And one of the key ones you can see there are the voluntary guidelines on the responsible governance of tenure of land, fisheries and forests. This is a soft law instrument. It is not a human rights treaty, and a breach of the standards laid down in that instrument is not in itself a breach of human rights law, but it may indicate, if there is a breach, for example, of respect for customary rights, that a breach of human rights law is occurring or is likely. It's certainly a trigger for looking at the issue. So those providing legal advice relating to land-related investments should consider the potential legal risks to human rights when these soft law international standards are breached or look likely to be breached. And importantly for this evening, those guidelines specifically raise the issue of defenders. They call on states to respect and protect the civil and political rights of defenders of human rights, as you can see there. So alongside extensive provisions setting out governance of tenure standards, the issue of defenders is specifically addressed, and these guidelines were adopted in 2012. So the core principle for businesses under the UN guiding principles is probably principle 13, which you can see there. So law firms as businesses, as well as their business clients, should avoid causing or contributing to adverse human rights impacts through their own activities, and they should seek to prevent or mitigate adverse human rights impacts that are directly linked to their services. Now, law firms will probably think that the second paragraph is of relevance to them rather than the first, because law firms would not consider that they would cause or contribute to adverse human rights impacts. But I think it's clearly more complicated than that. Depending on the facts of a particular case, if a law firm was to systematically exclude consideration of human rights risks in the course of advising on a transaction, or to ignore, for example, free, prior, informed consent issues affecting indigenous or other peoples, those are just two examples. If it was to do that deliberately and knowingly, there is a risk, I would say, that it would fall within the first paragraph. But in any event, the entire framework is relevant to businesses, including law firms. So looking at the lawyer's role, it's important to recognize, of course, that lawyers have specific professional obligations in relation to their clients. So they are in a special position, but nevertheless, law firms are businesses. So the International Bar Association, the IBA, has looked at how lawyers and law firms should operate within the business and human rights framework. And they issued guidance on this in 2016. And this is all considered in detail in part 2 of the UNFAO guide. I want to look at 3 elements that are particularly important. First of all, the role of the wise counselor. Lawyers should not simply regard themselves as technical experts, only responding to the questions they are asked. They should be wise counselors, proactively identifying and advising on potential risks that may arise in the future and on the wider context. And I think in relation to the issue of defenders, the wider context is critically important, and I'm going to come back to that in a moment. Another element that is key is the use of leverage with the client. Leverage is a concept that applies generally to business and human rights across all businesses, and it means influencing the client or another business to prevent or mitigate adverse impacts. But clearly lawyers are in a particularly strong position to use leverage because they are asked to advise on the law, which includes human rights law, and they are asked to advise on risk where the law may be breached. So leverage is particularly important for law firms. Finally, the IBA has said that as a last resort, law firms can consider withdrawing from their relationship with a client if this is legally permitted under professional rules, where a severe negative impact occurs and continues notwithstanding the firm's effort to influence the client to cease the conduct. These are, under the UN guiding principles on business and human rights, these are stated to be obligations of conduct. But of course, outcomes are evidence of the extent to which conduct is meeting the relevant standards. So if a law firm is associated with a particular client or a series of clients in relation to land-related investments where human rights violations have occurred, that does raise questions as to whether the law firm is meeting the standards applied under the UN and business and human rights framework. So I just want to come back to the context for giving advice and bearing in mind the role of the wise counselor as indicated in the IBA guidance. The context, as many of you of course will be very familiar, is a very challenging one, a very difficult one. And I just wanted to pick up indications of this at the international level. The Special Rapporteur on the Situation of Human Rights Defenders in 2015 said that the evidence of a threatening environment for defenders is oppressive and worsening in many countries. That was in 2015. Last year, in 2019, the Human Rights Committee expressed grave concern at the situation of human rights defenders, environmental human rights defenders around the world, strongly condemning the killing and all other violations against defenders and stressing that such acts may violate international law. So that is the context for legal advice on land-related investments. That is what is happening, and it has been happening for a number of years, and it does not appear to be getting better. The other part, the important aspect to this context, are the increasing focus on explicit international standards on defenders. Defenders are protected under long-standing human rights law already established under treaties, but there is a growing trend to recognize their particular vulnerability explicitly, and you can see there Article 9 of the Escazú Convention, which does just that. These are obligations placed on states, but it's important to bear in mind that the state's failure to meet its own human rights obligations does not exonerate businesses from fulfilling theirs. As you can see under UN Guiding Principle 11, the responsibilities of businesses exist independently of the state's ability or willingness to fulfill its own human rights obligations. So if in a state, human rights defenders are being killed or threatened or abused, and the state is unwilling or unable to address that, that does not exonerate the business involved, an investor or an advisor to an investor, from addressing those issues itself. Part 3 of the guide looks at human rights diligence in some detail, so I won't deal with that at any length now. The purpose of it is to identify, prevent, mitigate, and account for how businesses address their adverse human rights impacts. So again, the issue of defenders is an important issue that should be addressed in due diligence. And UNFAO technical guidance has flagged this issue up in technical guidance addressed to investors, and has underlined the importance during the consultation and participation process of ensuring freedom from retribution. So this is specifically addressed, and the sort of procedural and operational aspects of that are addressed in detail. The Human Rights Committee has encouraged all businesses as part of their human rights due diligence to communicate how they address their adverse impacts, particularly when concerns are raised by affected stakeholders. So this is something that all businesses, whether they are investors or law firms, can do. They can make it public and transparent how they deal with these specific issues. So coming back to the operational implications under UNGP 13, I've set out some examples there. So for example, if a law firm were to fail to address the harassment of human rights defenders or communities in the context of advising on a land-related investment, it would risk either causing or contributing to adverse impacts, or risk failing to prevent or mitigate those. The issue can't be sidestepped. It has to be addressed proactively with the client and in the light of professional obligations. And an additional dimension to this is the principle laid down in UN Guiding Principle 23C. In all contexts, business enterprises should treat the risk of causing or contributing to gross human rights abuses as a legal compliance issue wherever they operate. So where the level of abuse is at the most severe, that there is a risk that gross human rights abuses are taking place, there is a particular need for vigilance, both by the client and by the law firm. Steps taken by law firms to address this could include designation of a partner with specific responsibility, specific internal training, as well as dedicated training for clients, and the establishment of a rapid response policy so that if these problems arise or look likely to arise, both the client and the law firm can address them. And this can be addressed explicitly in policy statements and engagement letters. Given the context that we have seen that has been acknowledged internationally, there is no reason why businesses shouldn't say that they have a policy in place to deal with this serious issue. And I'll just finish with two statements focusing on defenders, just to underline the point that this is a matter that is being addressed at the international level and is a focus of interest. So the Human Rights Committee last year underscored the responsibility of all businesses, in accordance with the UN Guiding Principles, to respect human rights, including the rights to life, liberty, and security of person of human rights defenders, including environmental human rights defenders. So that was from the Human Rights Committee last year. And in 2018, the Special Rapporteur made a very interesting comment. The Rapporteur talked about the challenge of ensuring the support of businesses to the important role of human rights defenders and respect for the human rights of all, and said this will only become more difficult and more important. And in the coming years, we will need to more explicitly grapple with the relationship of human rights defenders to a long list of non-state actors, a list which obviously includes those who invest in land and in rights relating to land, and those who advise them. And I think there is an opportunity for lawyers in particular to show professional leadership here and to show that they are addressing this issue, both to assist their clients and most importantly, to ensure that they meet their responsibility to avoid human rights abuses and to seek to prevent and mitigate those that are relevant to the work that they do with clients. So I will stop there. Thank you.
Thank you very much indeed, Kate. And that was a really fantastic, I know it was a really quick tour by you of the report, but it was really, really has some fantastic material in there. And it kind of, it goes nicely from Victoria's talk about the toolkit into actually what that position is under the UN committee and the experience of the rapporteurs and others in dealing with the human rights defenders. So thank you very much, Kate, for that. We're going to move on now to and obviously keep the questions. I see that a few people have already put questions into the icon, so keep those coming in. We'll deal with those after we've finished the panelist slot. So we have two more. We're delighted to have two human rights defenders represented here today. Sekar is going to speak first, and she's going to give us an insight from the human rights defenders in Indonesia, and I think she's going to speak particularly about the shocking number of attacks and violence on those human rights defenders, and in particular what the COVID crisis has meant to those again. So I'm going to hand over to you now, Sekar, if you can just pick up. Thank you very much. Just you might be on mute, Sekar.
Yeah.
Yeah.
Sorry.
Thanks. Okay.
Hi everyone. I'm really glad to have an opportunity to talk here. And then, as Richard saying, that I will be giving you some information about environmental rights and legal community in Indonesia, but I will start with the numbers. For the background, Indonesian government for last 5 years always focused on more and more investment and infrastructure project, and it's towards all environmental degradation. More and more people aware and willing to protect their livelihood, but the impact is it followed by the numbers of HRD, environmental human rights defender. I will be focused and specific on that, being attacked, criminalized, and also murdered. Thus, the ELSAM report, the research have confirmed that situation of the environmental human rights defenders in 2019 was not a better state than previous year. So we have like 2 years report, and that's almost the same numbers. That it showed that between a year, ELSAM finds like 27 cases violation towards environmental human rights defenders among 40 provinces and 24 regencies and the cities. These cases include 8 types of violence. It's murder, arrest, detention, physical seizure, destruction, land grabbings. It's maybe close with what Kate previously talked about. And then the last but not least is intimidation. And the drawback, this violation affected 100 to 27 individuals and 50 environmental human rights defenders groups. The groups, it means, can be community or others like indigenous community. So it's very various numbers. And then those numbers coming from so we are talking about the actors. it seems like happen in everywhere probably. The numbers is the corporation had become the most common perpetrators on the human rights violation. In more holistic view, the role of corporates in various violence cases toward environmental human rights defenders might not as conventional as the seems. The further tracing on the whole relationship between the company and the government at the environmental human rights defender sector will be analyzed by political economic structure, which is function as stake in the every corporation involved in many cases. So in Indonesia, if you didn't aware with this background of the country, we are part of the long time backgrounds of the political oligarchy scheme. It's also one of the backgrounds for the civil society to strengthen and the border in the front of the struggles. And then if we are talking about this year, when the COVID-19 spread out the world, not only Indonesia, the government more focused on the how people do physical distancing. And the problem is, it seems like a new opportunity to prosecute more environmental human rights defenders. The case of environmental human rights defenders are increased, and that we monitor that during pandemic, the environmental human rights defenders still living in dangerously. And then the actors, because of this situation more handling by the government, but the impact of that is the business entity doing just like a business as usual. It means even the local community, the indigenous community, say to stop for a while because of they are doing a lockdown locally. They didn't want to do that. And then the impact of those kind of things is this activity linked with the big corporation, like a palm oil plantation, mining, and the tourism industry. They bring spread more virus on the local levels. So because of the companies didn't want to stop, they're still moving around the workers and all the things. It spread the virus more locally. The biggest corporation that involved is the mining companies. I can name Freeport becoming a bigger contributor on this side. And then we got a lot of palm oil plantation who are also still working on as business as usual. And then in this theme, the government call it new normal. They are supporting to tourism industry to also work as fast as they can. And it's also becoming a problem there. And then when we are talking about the right to defend, like the theme of today, I would say that it's linked it needs follow up from the governments, the companies, and also the lawyers. The governments, I mean, because of it's about more environmental rights, and then the ruling of the environmental rights is environmental citizenship, of course. So actually, the main how can we protect the environment is to keep the participation from the others stakeholders are clearly partial. So I mean, we will need something like anti-slap law in Indonesia, but now Indonesian have anti-slap law, but the problem is those kind of things, the slap law didn't exist because of the lack of guidance to the others stakeholders, like the lawyers, like the prosecutors and other stakeholders. So it's there by the law, but it doesn't exist by the practice. And then it linked by it because of the number of the corporation that bigger that I said before. The thing that need to be followed up is something about the business and human rights, like Victoria and Kate say before about the UN guiding principles. And I mean the follow-up regulation after the UN guiding principles is National Action Plan on the Business and Human Rights. Indonesia still didn't have that. Indonesia have general National Action Plan. And then I think the government needs to have that and to make it important and then make it as soon as possible. And then if it's the National Action Plan based that, we need also the role of the National Human Rights Institution and also the Victim and the Witness Protection Agency to protect the environmental human rights defender as well as human rights defender as general to keep protecting their rights. And then when we are talking about the companies, it's also there is one thing that we need to address. That company should know about the existence of the UNGPs. The problem in Indonesia is the companies here who knows about UNGPs just only companies that came from the multinational companies. The locals company probably didn't know and didn't aware about that. So it's like a gap between international law and also the locals. So I mean, when we are talking about that, and the importance of the international company to make sure that they have a human rights policy that contain environmental human rights policy, environmental human rights HRD policy, and then on this company and this policy, it's not only talking about whistleblowing, because some of our policy human rights defenders that we know, they are just mentioning about whistleblowing policy, but didn't mention about anti-retaliation policy. In Indonesia, that we didn't have any anti-slap law, it's very important to have anti-retaliation policy because of the case that often happens here is that the companies sue the environmental human rights defenders. They are sue the community, and it's make the case bigger and bigger. And I think it's a legal attack that we should prevent to happen. And then if we are talking about the legal community, more details on the lawyers, and the toolkits that Victoria already talked about the toolkits about to the UNGPs and HRD. I mean, it's need to be disseminate more and promote more in the local levels, like I mean in Indonesia, because lawyers in Indonesia, they are mostly focused on what happened on locals. They didn't really know what happens in the international norms. So the toolkits could help them to downgrade or link it the gaps between international norms and then the local norms. I think I would be stop that and that things, and I'll back to the Richard.
Thank you very much. Thanks, Seka.
Okay.
That was fantastic. Thank you very much indeed for that that presentation and that slot. Really interesting insight from Indonesia. Thank you very much. I'm going to pass quickly on because I know people still have questions coming in, but we're very delighted to have Donald with us, Donald Hernandez, and he's from Honduras. As I said before, he was also the winner of the award last year. And Donald, without further, well, I would just say if anyone wants and hasn't put on the translation button and they can't speak Spanish, they want to hear it in English, there is a translation available now. But now over to you, Donald, and thank you very much for speaking to us. You're on mute, by the way.
Sí, gracias. Muchas gracias. Es interesante para nosotros hablar del tema de las
Thank you very much. It is interesting for us to discuss the issue of the guiding principles. In our case, in a very small Central American country with 9 million inhabitants, while lower average incomes present us with great challenges. More than 60% of the population lives in poverty, and of that, in rural areas, a high percentage live in extreme poverty on less than $2 a day. We must talk about the relationships between the state, extractive companies, and the role that the population or civil society organizations play in these issues. For us in Honduras, the coup d'etat that took place in 2009 had a huge impact. The coup d'etat deepened the already difficult situation that we were experiencing regarding natural resources and their extraction by national and international companies. After the coup d'etat, the government, the party that it took charge of, now takes on corporate responsibilities to represent a group of families who have taken over the country. And these families have asked to be paid back for supporting the coup. And the government began to implement policies based on the exploitation of resources. It began to prioritize energy extraction, mainly through hydroelectric projects, and also to increase concessions for metal mining projects in the country. It is important to mention that there are 3 issues on which our institution works with organizations throughout the country. And they are mining, energy production, mainly focused on hydroelectric energy, and monoculture, with special emphasis on the production of African palm, transgenic corn, and sugarcane production. These last 3 are heavily linked to the production of biofuels. SAFREDEC, the organization for which I work, monitors compliance with the right to food, and for years we have worked with family units, implementing productive projects, installing irrigation systems, and producing food for the population. But after 2009, we began to confirm that the state was handing over land to companies without consulting the communities, land to extract metal through ship mining, blowing up mountains without checking the minimum health and safety requirements for the communities. Currently, we have displaced communities and we have many people affected by the impact of the mining companies. Currently, we have a state that does not want to be responsible for the care of these people. In a mining company like Goldcorp from Canada, who, when they began to see the effects they had caused, the deaths, the effects of skin cancer in women, and the impact on children in our country, chose to withdraw. And responsibilities? That's the question. There were no responsibilities. They went to Guatemala and continued causing serious damage to communities there. Then we began paying attention to the guiding principles and to the responsibilities that the state and companies have in relation to responding to communities with respect to repairing the damage they have caused. The toolbox has really helped us to better understand, as I keep saying, the role that the state, companies and civil society must play. And as organizations, we started to familiarize our community with their rights. We began to look for ways to speak to public officials, mainly the Secretariat of Human Rights in our country. We started to check the Honduran state's level of engagement with the UN up to now, specifically with the Universal Periodic Review, which it underwent and in which many countries suggested that national action plans be implemented throughout the state's institutional framework in order to respect human rights in Honduras. It is important for me to mention that according to the latest Global Witness reports, in terms of deaths, Honduras has been classified as the most dangerous country in the world for those who defend land rights. It is not easy to declare yourself a human rights defender in a country where there is a co-optation of power by one of these three branches of the state, where the executive power directly manipulates the judiciary and the legislative power. This institutional failure means men and women have to defend their land, either because an electricity company is taking away the water they need to live, taking it away to create an energy business, or because they are losing their farmland because the state, without consulting them, gave it to a mining group and now wants to displace them for their territory with the force of public authority. And when our leaders oppose them, they then become enemies of the state, and they face a campaign that discredits them. This is because the state has co-opted and laid siege to the media, and it now controls a large percentage of the output. Then land defenders appear as enemies of development, as enemies of the state. And from there, the operators of justice, whether it be the police, prosecutors from the public ministry, or judges, begin to persecute our leaders. As lawyers, we have to appear in court to defend these leaders, even knowing that most of the time the decisions have already been made. There is already an institutional line to jail these leaders or force them out of the country. A great effort is made to remove these people, these colleagues, these brothers of ours from the picture. So defending natural assets, at least in Honduras, means a great degree of responsibility because one's life is in danger. Today, knowing the obligation that states have, that companies have under the guiding principles, we have entered a process of familiarizing and empowering our leaders with these tools. This is so using the toolbox. They know all their rights, and so they know the procedures that must be used to take companies in the state to task. They can use these procedures to call out malpractice and the methods used to encourage companies to extract minerals or energy at the cost of inhabitants' basic rights. It is important to mention that a large proportion of the resources that are currently being taken away from communities have been conserved mainly by indigenous peoples themselves. Within their worldview, they have protected their natural environment. And today we are no longer in a moment where we can describe resources in such a way. We should talk of goods, because the word resource has been confused with the dollar or euro sign, or whatever currency you want. Today our populations are fighting to defend their livelihoods, to defend the land in order to produce food to survive. Meanwhile, the African palm monoculture company is counting all the land to produce palm oil, which in many cases is geared towards generating biofuel. In other words, combustible fuel to feed engines while we are fighting for the land to produce food to sustain the population. So we are also faced with an unfair system, a system that places us in diametric opposition with entrepreneurs. As an institution, our current policy is to try to influence businessmen and business chambers, so that those policies, which are often theoretically handled. It's true that in Honduras we now have a Chamber of Commerce that has published its human rights policy, but it was left in a desk drawer somewhere, because there are presently defenders of land rights in maximum security prisons. Today they are being classified in the same way as murderers, or at the same level as high-profile drug traffickers or organised criminals. And it is here where we raise our voices. It is here where it is important to enter into these processes to attract the world's attention. and to make it known that respect for human rights goes beyond signing a document at the UN, but rather that it has to be reflected in the policies and actions of state and companies. And on the issue of compensation, it is important that companies, as they do in their developed countries, also understand that these policies and concerns must be applied in our countries. It is important when arriving in a territory to ask the population if they agree or not with a given project. But they arrive in the territories knowing that the resource will have to be taken out regardless of the position of the people. So most of the time the discourse of respect for human rights is used as a way to gain the consent of the people, it being clear that the company will get the resources regardless of the community's position. Even in Honduras, the statistics continue to be worrying for human rights defenders. Even now during the COVID pandemic, the government has us as lawyers defending lockdown communities. Meanwhile, they have detained our leaders and the procedures are being carried out without their lawyers. Because when we ask the Security Secretary to give us the circulation permit to go out to a hearing, we get a negative response. And so the rights of the defence are being violated for our leaders, who have to be represented by a public defence lawyer who handles 300 to 400 cases and who will not put great effort into their case. I will finish here and I hope I can participate in any query on the subject. Thank you very much.
Un alto grado de responsabilidad porque la vida está en peligro. Hoy, sabiendo las obligaciones que los estados tienen, que las empresas tienen en virtud de los principios rectores, hemos entrado en un proceso de empoderar a nuestros líderes para que conozcan estas herramientas, para que conozcan de esta caja de herramientas todos los derechos que tenemos y los procedimientos que se deben llevar a cabo para llamar la atención de empresas y llamar la atención del mismo Estado en su mala praxis, en su mala forma de hacer los abordajes para promover que las empresas extraigan un mineral, extraigan energía a costa de derechos básicos que tienen los pobladores en estos territorios. Es importante mencionar que gran parte de los recursos que hoy se están quitando a las poblaciones se han conservado principalmente por pueblos indígenas, que dentro de su cosmovisión han protegido su entorno ambiental y hoy ya no estamos en el momento de llamar a los recursos como tales, hablamos de bienes, porque la palabra recurso se ha estado confundiendo con el signo del dólar o del euro o de la moneda que ustedes quieran. Hoy nuestras poblaciones están peleando por defender sus medios de vida, por defender la tierra para poder producir alimentos para subsistir. Entre tanto, la empresa monocultivista de palma africana está cooptando todas las tierras para producir aceite de palma, que en muchos casos está orientada a la generación de biocombustibles, o sea, es decir, alimentos, combustibles para alimentar motores, cuando nosotros peleamos porque la tierra produzca alimentos para sustentar a poblaciones. Entonces, hoy estamos enfrentados también en un sistema injusto, en un sistema que nos ubica en posiciones muy diametrales con la posición que hoy están manejando nuestros empresarios. La política que hoy manejamos como institución es tratar de incidir en los empresarios, en las cámaras de empresarios nuestros, para que esas políticas que muchas veces se manejan teóricamente, ¿verdad? Hoy tenemos una Cámara de Comercio en Honduras que ha publicado su política de respeto a derechos humanos, pero que estaba colocada ahí en un escritorio, porque hoy tenemos a defensores y defensoras de la tierra y los territorios encarcelados en cárceles de alta seguridad. Hoy están siendo catalogados como asesinos o como al nivel de personas del alto narcotráfico o crimen organizado. Y es ahí donde levantamos la voz y es ahí entonces donde es importante entrar a estos procesos de llamar al mundo la atención y de que se sepa de que el respeto por los derechos humanos va más allá de firmar un documento en la ONU, sino que tiene que verse reflejado en las políticas y en las acciones de los estados y de las empresas. Y en el tema del resarcimiento, es importante que las empresas, así como trabajan en sus países de alto desarrollo, también entiendan de que esas políticas y esos cuidados los tienen que llevar a cabo en nuestras tierras, en nuestros territorios. Y que es importante que cuando se llega a un territorio se pregunte a la población si está de acuerdo o no con un proyecto X. Pero se llega a los territorios sabiendo de que el recurso se habrá de sacar independientemente del posicionamiento que la población tenga. Entonces, muchas veces se utiliza el discurso del respeto a los derechos humanos como la forma de buscar el acuerdo de la población, pero teniendo claro de que la empresa va a sacar ese recurso aún con la oposición de las comunidades. En Honduras, las estadísticas siguen siendo preocupantes para los defensores y defensoras de derechos humanos. Aún ahorita, en medio de la pandemia del COVID, el gobierno nos tiene a los abogados que defendemos a poblaciones encerrados. Entre tanto, han detenido a líderes y lideresas nuestros y se les están siguiendo los procesos con la ausencia de sus abogados. Porque cuando solicitamos a la Secretaría de Seguridad que nos dé el permiso de circulación para ir a evacuar una audiencia, la respuesta que tenemos es negativa. Y entonces se están violentando los derechos de defensa para nuestros líderes y lideresas que tienen que someterse a la defensa de un abogado de la defensa pública que lleva 300, 400 casos y que no va a poner mayor esmero en esta defensa. Voy a cerrar acá y espero poder participar si hay alguna consulta sobre el tema. Muchas gracias.
Thank you very much indeed, Donald. And thank you everyone on this webinar for contributing. There have been quite a lot of questions that have come in. So, I mean, from my own perspective, listening to Donald and Sekar, you know, it really brings home to you what a horrendous position this is, with people being killed, attacked, really violently abused when they're defending the environment and their land. So obviously there are ways in which we can help to mitigate that bad position. I'm trying as a chair. My responsibility really is to keep to the time that we allocated to this webinar. And so, although there have been many very, very good questions that have come in, this can continue on Twitter, and we can continue to answer the questions that you have sent in. So that's fine. Don't worry, we will be answering them. But I have got just one that I would like to ask Kate, if that's okay, Kate, because I think it's probably aimed more at you than any of the others. I mean, there's lots of questions which are quite specific, which our human rights defenders can have a look at. But this one is a particular one, I think, possibly for Kate. And it's really a comment on whether there is a need, I suppose you'll say that there is, for a binding treaty beyond the guiding principles, and whether that is, you know, whether you can comment on that, how likely that might be.
Thank you. I'd like to start by saying listening to Sekar and Donald is, you know, leaves you reeling almost. And as a lawyer also, I have many questions in my mind about what they have both said and what's happening on the ground. But those are obviously questions that will continue among the legal and human rights community. On the question of the treaty, obviously, you know, it could be very useful to have a binding treaty. Why don't we have a binding treaty on these key issues? But I would just say that unless there's a reasonable amount of support, I don't mean universal support, but a strong body of support from some key countries, I'm not saying it's not a good idea, but it could use a lot of time and energy. I think my focus at the moment with others is looking at the framework that we have that businesses have signed up to, that states have pledged themselves to deliver, and to make as much use of that as we can. There are all sorts of ways in which the business human rights framework is relevant. There is an increasing trend for national legislation on due diligence, as in France, as in the state of California. There are parallels with the increasing trend to have laws on modern slavery, for example, and the responsibilities that are assumed in relation to that. So I have absolutely no objection to pursuing a treaty, but I think it's important to have a two-pronged approach where you use the business human rights framework, for example, in looking at how states spend taxpayers' money on export credits and export funding and overseas development assistance, to make sure that all public money is spent in a way that respects this framework, that ensures that due diligence has been done. And we all think about our position as consumers of products in countries that are buying in products that have been obtained, if they have been obtained in situations where there are clear human rights violations. So I'm not saying, no, it's not a good idea. Of course, I'm not saying that, but I'm saying it's important not to focus on that at the expense of making maximum use of what we already have.
Okay, thanks very much, Kate. I think I need to draw this to a conclusion. We are now 5 minutes over our time, but I just really wanted to thank all of our speakers, Victoria, Kate, Sekar and Donald. I also wanted to give a good thank you to Susie Baskin, who heads up the Peace Brigades International, and she's been instrumental in organising this webinar, but also in many other webinars and other information fora. And I also wanted to thank very much the translators and other participants in this webinar. Thank you very much for keeping us together and for helping communicate more widely. Thank you finally for joining. There have been over 50 participants in this webinar. It's a bit strange just us looking at all of us here, but obviously there's been a big body of people involved in this. So thank you very much indeed for joining, and I hope you'll join us for our next one. Goodbye.